Good evening, and thank you for this opportunity. Um, I'm going to kind of call an audible here and try to abbreviate a little bit because I can see from the program there's some really terrific speakers, and so I'm going to try to get to the heart of what I wanted to talk to you about. And actually, there's a few more lawyers than I thought were in the audience. And so I think, though, what I have to speak about, you'd find interesting just since you're all in the litigation area. And I agree with my friend Steve Levin that importantly, 95% of cases settle without a trial. But in order to maximize a personal injury case, the other side has to know that you are a fearless advocate and you're ready, willing, and able to try the case. And I really feel it's my obligation and our firm's obligation, and I really think for all of the top firms that hold themselves out as premier plaintiff's personal injury firms. And this is a culture in our office that we must provide extraordinary services for the client. And we all know, as lawyers, although certainly the most important part of a case is in terms of its value, are the facts of the case, the severity of the injury, coverage, likability of the client. But right up there at the top is the quality and the talent and the fearlessness of the lawyer. We are in an adversarial system. I want to kick them across the courtroom every day of the week. But don't misunderstand, and even when you have very sympathetic plaintiffs, true victims of negligence, malpractice, and I agree with my friend Steve who said, they are apologizing. And don't think for a minute a defense lawyer in a case where they should lose. The little baby is brain damaged because of negligence on the part of the doctor or the nurses. If they get a not guilty, they are high-fiving all the way back to their offices, right? That's all right. That's the adversarial system. So I just want to impart, some thoughts that might prove to be helpful in terms of your practice or just for those of you who are not lawyers, kind of our way of thinking. I talked about a little bit in terms of key elements for your next big verdict. And your attitude is absolutely key. You've got to be brave. You've got to think big. My son will always point out, I'll say, well, how much are we going to ask the jury for? And for those of you who've tried cases, you know that the discussion about the value of the case starts in jury selection. And it is a very important strategic component of building to an extraordinary verdict. And lawyers make the mistake of thinking, I might offend the jury. I may lose credibility if I suggest too much. And my son will always say to me, Dad, let me ask you, What you're saying to me is you think you're going to get less money if you ask for more. Is that what you're telling your son? Is that the great mentoring that you're doing? And although there are limits, in my estimation, in today's day and age, you've got to think very, very big. And why are we listening to defense lawyers or insurance people in terms of telling you what the value of our case is, or that we're in the wrong stratosphere? Well, of course they're going to think that way. They're defense lawyers. They're risk adverse. They think small. So they're not dictating the value of the case. You are. You are, and you've got to think extraordinarily high, in my estimation. You decide the value. You have to trust your skills. Now, long before a great verdict, the result is very much dependent on how well you prepare, develop your themes, put together your presentation, experts, lay witnesses, exhibits, etc. Now, no case is perfect, but you need good facts. You need a client who is a true victim. A client is likable, credible. A serious permanent injury or death. Coverage. These are the cases you try. These are the cases you try. And don't be a lawyer who only goes to trial because they have to. No offer, or an offer that is just so de minimis, there's no other choice but to go to trial. Don't be that lawyer. Now, the tough part with regards to trying the good cases, where is the anxiety? Turning down a lot of money. That's where the fearlessness and you're having to be brave comes in. So, rather than my talking to you about, the nuts and bolts about brain damage cases or spinal cord injuries or the loss of a limb or death cases, let me just tell you general strategies with regard, in my opinion, as to achieving an extraordinary result. First of all, you have to fight hard with assuming you're meticulously prepared. You have a victim of negligent conduct, a good, likable client. Don't have to be perfect, but someone that the jury is going to empathize with. And you have, of course, ample coverage and a serious injury in which to really talk about. It might result in a loss of function. It may be a very painful condition. It may affect their life in so many ways, all of which you need to learn about well in advance, in great detail, in order to make the presentation. So assuming you've done all that, in my opinion, then it starts in jury selection. And in Illinois, although it is discretionary, case law is good in terms of being allowed to voir dire the jury on a specific sum of money. In the case, of course, the lawyers always like to talk about their big victories, right? So The Darden case, which resulted in a $148 million verdict, was, a once-in-a-lifetime type case that there was no way I was going to settle that case. There was no way I was going to settle that case. It had all the ingredients. And so, but the lessons from it apply to much, much smaller cases just as well. And so, Mrs. Smith, I'm going to tell you that at the end of the trial, in closing argument, I'm going to suggest that you award in excess of $150 million for my client. If we prove our case, could you sign such a verdict? Well, gee, that's a lot of money. 150. I suppose if you prove it, yeah. If I prove it, I don't prove it. Then the award should be a fraction of it, much less. If I prove it, yes. If you prove it, I could sign such a verdict. So you're setting an amount that now is in their mind. And you've anchored them. But there's some other important commitments that are necessary in order to get to that number. First of all, they have to know that what's the law in Illinois? We have economic and non-economic damages, loss of a normal life, pain and suffering, disfigurement, emotional distress, risk of future harm, in addition to past and future medical expenses and lost earnings. Will you consider each and every one of them separately in your deciding the amount of the verdict? Can you do that? Can you follow the law? Yes. Okay. And will you consider in deciding your verdict for how long these losses, the suffering will continue? Knowing in the case of Attorney Darden, 24 years old, a dancer, paralyzed, and with the most horrific, god-awful pain, neuropathic pain syndrome. So I know I'm going to deliver on the evidence. And so the presentation is made. And as I said, for the sake of time, I'm not going to get into the weeds about the details, but it's all the right things, computer animations of the surgeries and the anatomy, the day in the life videos, showing the suffering and how it affects every day. Lay witness talking about the struggles. Her parents, who are now caregivers, describing, a 4 to 8 hour bowel program every day. And then, of course, her doctors explaining, the catastrophic nature of the injuries and the damages, and they're permanent, and all of the effects it'll have on her for the rest of her life, which I know is going to be 56 more years. Right? So fast forward to closing. And now I have my verdict form, I'm showing them, and we are going to start going through each and every one of the elements of damages. And I said, you know what? I think that before I start, as I recall, when we selected you, I asked each of you, would you consider each and every element of damage separately? And if I recall, you were all good enough to say that you would. And, you got to remember that, after you deliberate today and render your verdict, you go home, I go on to the next case, the judge goes on to the next case. But Tierney Darden is going to live with your decision every day, day in, day out, for the next 10, 20, 30, 40, 56 years. Your verdict the amount of your verdict must represent the loss, the suffering every day for the next 20, 30, 40, 50, 56 years. And the value of money 10, 20, 30, 40, 56 years from now. Let's go back 56 years. Highest paid baseball player, Willie Mays, $80,000. When this case was tried, it was Kershaw for the Dodgers, $35 million. What's it going to be 10, 20, 30, 40, 56 years from now? And it's very important. You have to remember that as you're discussing what is full and fair compensation for every single element. Very important. And another thing you have to do, in my estimation, is you have to confront jurors. Some of the jurors are, they're not all in your camp 100%, right? So some jurors are going to say, Jesus, they could put that, you could put 10 million, 20 in the bank and earn interest on it. If a juror brings that up in deliberation, you say, hey, wait a minute. No, that's not following the law. With regards to non-economic damages, they're not reduced to present cash value. It's how long do they last and how bad are they? That's it. And anybody that brings that up, you tell them, hey, we can't do that. Somebody says, well, it's not going to take her pain away. It's not going to make her walk. What good does it do? You say, hey, time out. That's not the law. It's how bad is it and how long is it going to last? That's it. You got to make sure your fellow jurors follow the law. So you don't act like it's a dirty little secret that jurors are not going to talk like that. They are. Same with death cases, blood money. Won't bring her back. That's not the law. Hit that head on. And so when you have talked about, for example, pain and suffering, what's the value of 56 years of pain and suffering? What's that worth? Plus, what money's going to be worth for all those years? Well, for example, how we value pain. Someone is dying and they pass away, and at the funeral somebody said, well, at least he's not suffering anymore. That pain is so abhorrent in our culture that actually people are grateful that someone has died and does not have to suffer pain. That's how valuable it is. So what is the loss of, and what is the value of never being able to walk or run, probably never have children, not just being able to just get up and go, let alone your passion, dancing? What's that worth? If that isn't, if that isn't the most valuable thing, what is? Now, again, this was an extraordinary case, but all of these strategies apply in any serious personal injury case. So that when you've detailed the evidence and you've gone through each and every element, reminding them you have got to consider each one separately, use your collective wisdoms to determine what's appropriate, put it on the board, go on to the next one. And in Illinois, we have itemized verdicts, and so you have to take advantage of that, in my opinion. So that when you're done with that, and you filled in a suggested amount for each and every element, telling them it's your suggestion. They may think it's a greater or lesser sum. It's your suggestion. And then I like to say now, again, as I recall, in the beginning when we selected you, I asked you, if we demonstrate to you that full and fair compensation in this particular case is worth in excess of $150 million, could you sign such a verdict? And as I recall, each of you were good enough to say to me, yes, we could. We will. And I would say, haven't we proven that? Now, hopefully, you get a lot of nods, right? I got a lot of nods that day. And one quick little war story in terms of that particular case, and turning down like $45 million, which is not easy to do. You're never sure. Turning down a high low of $40 to $95 million, but I knew. I felt it. And we had all the trial lawyers here know that, you never know who's going to come into the courtroom when jury selection is about to start. And it's generally a mixed bag, and you have to use your skill in terms of voir dire and all the tricks of the trade to try to get the best group you can. But on this day, for that case, one juror after the next was terrific. And there was only one exception, someone that was let on early on, because I'm a big believer in, I tell young lawyers that when you're picking a jury, it can't be a perfect, you have to use your peremptory challenges wisely. You don't want to run out of them. And so we had one young man that I kept on. I felt a little bit uneasy about him, but he was like 21, and I'm a big proponent of the fact that you really spend your time and effort in cases with jurors that are likely to be players in the negotiation, right? That are going to be stronger personalities that are likely to influence versus somebody that, hey, whatever you people decide, I just want to get the heck out of here. And someone that is 21 and, not a lot of education and so forth. So I figured this is not a player. He's not ideal, but he's probably not a player in the negotiation. But during the trial, jurors are allowed to ask questions. And he would pass a question, and you know who they are because the judge will say, anybody got a question? Somebody writes it out, and they hand it to the bailiff, and the bailiff, so we know who it's coming from. And he would ask something like of the doctor, when do you think they'll invent a cure for paraplegia, and how much do you think it'll cost? Okay, so that's not good for me. But, overall, the jury's very good. And we're into the defense case. One of the defense doctors is testifying along the lines that's, she's if she has a spinal cord stimulator, she'll get off opioid medication, and then she'll be like many tens of thousands of paraplegics that live normal, highly functional lives. And we took a lunch break during my cross-examination. And what happened was, unbeknownst to me, is that this problem juror, while walking out, this doctor, who happened to be a paraplegic, dropped his water bottle, and this juror picked it up, gave it to him. They started to talk. And then they went to lunch. The juror that I was worried about comes back. The doctor's still in the courtroom. We're not there, a lesson learned. We're still on our lunch break. And they start talking again. And thankfully, the court reporter turned him in. Brings it up to the judge. The judge confronts him. To make a long story short, we all go back into chambers. The judge tells us what happened. What do we do? And by the way, the defense lawyer was in the courtroom and didn't say anything until it was so long he finally says, "Hey, doc, you really shouldn't talk to the juror." And so she said, "What do we do?" And I little white lie, I said, "Well, Judge, I don't know if he's for the plaintiff or the defense, but I think the safest thing to do would be to excuse him." And I said to the defense lawyer, "Listen," and the judge was mad at the defense lawyer. I said, "Listen, the smartest thing you can do is agree to this, and you're not going to hear a boo out of me." So that's what happened. And just to illustrate the stars aligning, the alternate that replaced him, I asked for $174 million. They awarded $148 million. I asked for $56 million in loss of a normal life. They gave me every dime. I asked for $56 million for pain and suffering. They gave me $30. And for the first time, I never had this happen, was every juror afterwards lined up and hugged the plaintiff. And the juror, the alternate that replaced the bad juror, comes up to me and says, "I'm sorry, Mr. Salvi, I tried to get you more." So that's when you know things are working out well. So thank you for indulging me on the war story. And hopefully some of these strategies can be helpful for the lawyers in the audience for your cases. Thanks.
I have a quick question. Out of the criteria you have listed here, what is the one that's most challenging? What happens when you have an unlikable plaintiff?
Then the client is on and off the witness stand. Not a lot of time. We don't want him. We don't want the jury to get to know him or her too well. I'm a big proponent of not having the client in the courtroom much of the time, if at all, especially any serious injury. And a jury, I always say to the jury, "Listen, she or he won't be here through most of the trial. They don't want to relive it, or it's too difficult, or whatever. Anybody got a problem with that?" And I've never had a juror say, "Yeah, we're that, I'm here. I expect them to be here." So I would say then they don't play nearly as prominent a role and let other people the likable spouse or the likable uncle or neighbor or coworker. Let them kind of be more major players. Because remember, you are the director of this play. You get to pick, to some extent, but to a great extent, the actors in the play. And so you need to take advantage of that, in my opinion. But the likability, of course, we all need good facts, but the likability of the client is important. But nowadays, I mean, a true victim. That's, really important in my estimation in today's day and age, right? Any other questions? Okay, thank you.